Linguistic Canons 4, commentary by Professor Brian Slocum from Florida State. We have Robert Leider from George Mason University with his paper, The Individual Right to Bear Arms for Common Defense, with commentary by Professor Judd Campbell from Stanford. And we have Tyler Lindley from BYU with his paper, Reconstructing Section 1983, with commentary by Tara Lee Grove from Texas. We are on a tight timeline, so we also believe in self-regulation here. So you will all hold to 10-minute time for the speakers, 8 minutes for the commentators. And you know how in the Academy Awards where they start to play you off the stage with music, I'm more motivated by the way the Ig Nobel Prizes handle people that go over their speaking time, which is they send a 5-year-old child with a microphone to the front of the stage who just says, "Please stop, I'm bored," on repeat. So I'm not saying I'll do that, but you may not want to find out. So with that, Benjamin, take it away.
Thank you so much for the introduction. So the title of this paper is What are Linguistic Canons for? So ordinary meaning is often the starting point for interpreting statutes, and some say that linguistic canons can help us figure out ordinary meaning. But these canons are often contradictory. Some say they are flat out wrong. So why then do we need linguistic canons? One answer is we don't, and this is a view that has been put forward many times by many people throughout the years. My argument today, however, is a very simple one. Linguistic canons are only useful if they can change people's beliefs about the ordinary meaning of language. So this talk will unfold in 3 parts. First, I will explain why we should care about the efficacy of a linguistic canon as opposed to its validity. Second, I will report on an experimental study that tests the efficacy of linguistic canons. And finally, I'll explore the implications of these empirical findings for how we think about linguistic canons. So first, why should we care about the efficacy of a linguistic canon rather than its validity? By validity, I mean what everyone else in the field means. To put it very roughly, a canon is valid if most people agree with it most of the time. Validity can take 2 forms in many of these studies. People might agree in the abstract with a rule that is stated by a linguistic canon, or their judgments might coincide with the outcome indicated by a linguistic canon in a concrete case. And these studies, they look at validity because a linguistic canon that is valid accurately reflects how language is normally used, and that seems like a good thing. But here's the rub. There is such a thing as too much validity. And that's because a canon whose results no one disputes is idle, right? Such a canon just formalizes the obvious. So what about a more controversial but still valid canon, linguistic canon? And I ignore for the time being what the threshold for validity might be. Right? Such a canon seems informative. If it's not clear what the ordinary meaning of a text is, then the canon tells us what the text probably means. Okay? The canon represents some kind of prior belief about how the text should be read. And there are some treatises and judicial opinions that hint at this understanding of linguistic canons. But what is the empirical foundation for this prior belief? Right? How can one demonstrate across all possible texts and contexts that have been or could be generated that the reading suggested endorsed by the canon is more likely than not to be correct? Moreover, can such a prior belief ever be decisive when there is a real rule in front of us to be interpreted? A real rule has a history, it has an audience, it presents itself as solving a problem. All these factors, I think, seem to render any prior belief irrelevant to the task at hand. So to sum up, validity doesn't seem to be what ultimately matters for linguistic canon to assist in statutory interpretation, even if we only care about ordinary meaning. So what should we care about when it comes to linguistic canons? I claim it is efficacy. And by efficacy, I mean the ability to change beliefs about ordinary meaning. So a linguistic canon, according to me, is efficacious if those who are reminded of it read a text differently from how they would otherwise have. Conversely, a linguistic canon is not efficacious if bringing it to the attention of an interpreter has no impact on how he or she construes the text. Now I will describe a study testing the efficacy of 4 well-known linguistic canons. This experiment, I want to stress, is just a baby step in the research agenda I am sketching. It's not the last word on this subject. But with that disclaimer out of the way, the 4 canons I tested are the last antecedent rule, nocita associs, is jusdem generis, and expresso unius. Okay, if you forgot what these canons are, don't worry. I'll remind you in a minute. So the last antecedent rule says that a qualifying clause at the end of a series of things refers only to the last item on the list. Right? So if the phrase is no parties or activities that damage the house, that means no parties and no activities that damage the house. The second canon, Notre Sources, says that the sense of a word may be determined by the words that surround it. Right? So if someone tells you about a cat, a dog, or a hamster, right, someone's asking for a cat, a dog, or a hamster, they're probably not asking for a tiger, right? Even though a tiger is technically a cat. The third canon, Ejus Dem Generis, says that a catch-all term may be qualified by the specific examples that precede it. Right? So if there's a rule that applies to automobiles, trucks, or other vehicles, it probably doesn't apply to an airplane, even though an airplane is motor-powered and carries passengers. Finally, expresso unius. Expresso unius says that the expression of certain things implies the exclusion of those not mentioned. So if there's a sign that says visitors are permitted to bring their pets into a park on weekends, that probably implies they're not allowed to do so on weekdays. All right, so these are the four canons that I tested, and here's the basic idea behind the study's design. For each linguistic canon, I introduce a phrase to which that canon might potentially apply. There are four linguistic canons that I tested, so 4 phrases. Each phrase is then employed in a scenario in a legal or non-legal setting. All right, so sometimes a phrase in this experiment is used in a legal setting, sometimes in a non-legal setting. Each phrase, there are 4 canons, so 8 scenarios in total, right? So 2 for each canon. Participants in this study were randomized to one of these 8 scenarios, and they were then asked how they would interpret the phrase in question. So to give you an example, right, the phrase, and this was actually used in the study, trays, glasses, dishes, or other tableware, and I got this phrase from a California Court of Appeal decision. This phrase could be used in the context of a tax hike, as it was in that Court of Appeal decision, and that's a legal scenario, or it can be used in the context of a price hike, which is a non-legal scenario. And participants who read about tax hike were asked whether the phrase trays, glasses, dishes, or other tableware included a napkin. Participants who read about a price hike were asked the same question. All right, but here is the key manipulation. All right, some participants were not given any guidance at all in answering this question. They were left to their own devices to kind of figure out what meaning means. Some participants were expressly instructed to give the words their ordinary everyday meaning, and that's in quotes, ordinary everyday meaning. And some participants were not only instructed to give the words their ordinary everyday meaning, but also receive an explanation about the applicable canon. So to illustrate, for the Ejus Dem Generis canon, participants were randomly selected to receive information about it learned, and I quote, that in common usage, a general term may be qualified by the specific examples that come before it. So for example, a customer who asks the server for a Coke, a lemon tea, or some other beverage is usually not understood to be asking for an alcoholic drink, even though alcoholic drinks are technically speaking beverages. But this is not always the case, and whether it is so often depends on context, end quote. Right? So this is what participants actually see on the screen. 2 details are very important here. Number 1, the canon was presented to participants without any legal jargon, without any Latin. They were not even told that these were canons, all right? So they just received this explanation. Number 2, participants were told that the canon was not absolute, that it was defeasible, that whether it applied depended on context. And these design choices are critical, right? They ensure that the linguistic canons were not somehow treated by participants as being authoritative or binding as something they must follow. So to repeat, participants were randomly sorted to scenarios, and they were asked whether a phrase should be construed in a certain way. And statistical comparisons are then made between answers given by those who received no guidance at all, those who received the ordinary meaning instruction, and those who received the ordinary meaning instruction and a linguistic canon. I'm not going to go through all the math, right? I'll just tell you in brief. The last antecedent rule and Notre Sources made no difference to how the relevant phrases were interpreted. There is some very limited evidence that Ejus Dem Generis made a difference, and there's strong evidence that expresso unius made a difference. Now, the results of a single experiment like this one should always be taken with a huge grain of salt. Still, I think there are 2 interesting observations here. First, it seems that linguistic canons don't always move the needle. That may not be surprising to some of you. Second, and perhaps more surprisingly, the linguistic canon that did move the needle, expresso unius, is one that is really criticized in the literature. Right? So for instance, Bill Eskridge and John Fairjohn, they dismiss expresso unius as unreliable or even bogus, A recent survey, which incidentally was conducted by today's commentator with co-authors, found a lack of support for the canon among the public. Okay, but I think it is precisely the non-obviousness of the canon that allows it to be efficacious. So let me kind of wrap up by returning to the question with which we started. What are linguistic canons good for? It could be that they're not good for anything. Okay, the study I just described to you showed that some of them do not change beliefs about ordinary meaning. But the study also identified a linguistic canon that seemed to sway how people construe the ordinary meaning of language. And perhaps some linguistic canons can change beliefs about ordinary meaning by drawing attention to background, purpose, or some other element of context that might otherwise be overlooked. They suggest possibilities for interpreters to consider and, if necessary, investigate without favoring any one reading of the text. And this suggestive function, I contend, is probably likely the best characterization of what linguistic canons are and should be for. So thank you for listening, and I look forward to your questions and comments.
Thank you. Brian?
You have the time for me? What? You're doing the time for me? Yeah. Okay. Thank you for the paper, Benjamin. It's very provocative and interesting, and I appreciate any paper that adds to the literature, which yours definitely does. And you raise some really important foundational questions that other people have raised that I really think need to be answered. Like one that you talk about, why are canons needed, right? That's kind of the foundational question that everyone, judges, scholars should be able to answer. And I really think they are needed, even if they do seem obvious and intuitive. And there's this tension, right? Linguistic canons are supposed to reflect how we use language to be accurate, to be valid, to use a term. But if they're valid, then why do we need to be reminded of them, right? So it's that kind of dichotomy. But I do think there's an answer, and the answer is that judges are not supposed to interpret language on the basis of their own kind of personal impressions and life experiences. Of course, those inform the judge's interpretation, but interpretation is supposed to be external. The judge is supposed to interpret the language as a community would, right? As a collective, a language community. And so the judge, in some ways, I think, needs to look, and it's useful to look at external information, just like judges. And maybe a better question, which is kind of beyond the scope of the paper, is why do judges look at dictionaries to define common words, the meaning of which we all know? That's a harder question, actually. Maybe they're misreading the dictionary definitions and using them in ways they're never meant to be used. But I would distinguish that from canons. I do think, so for example, in this, it leads to the second question, which is, I think people expect too much of canons. Yes, canons don't mandate any one conclusion in any case, but they're not supposed to. Language doesn't work that way. Canons are supposed to channel discretion and channel the judge's analysis. So for example, let's say a statute says something like cars, trucks, buses, and other vehicles, right? So left to her own devices, the judge might look up the word vehicle in a dictionary, right? And this kind of example is similar to a lot of statutes that have so-called universal quantifiers, all, every, that sort of thing. The judges have this choice. Do we just give the word its literal meaning, its literal dictionary meaning? Is that how these words are used? Or is that not how words are used, right? A judge might have an intuition and might look at one piece of external information in a dictionary, but that might not reflect how people use language. But how do people use language? Well, a textual canon can help guide the judge's analysis and discretion and can validate a different intuition, which is for universal quantifiers. For example, people restrict universal quantifiers, all, like all people at the conference did X, Y, or Z. Well, it doesn't really, that's not a good example. All people, if I just said all people did X, Y, and Z, you would interpret that as meaning everyone probably in the room, right? It's always restricted by context. So, for example, back to my first example, cars, trucks, buses, and other vehicles. Another way to read this is not according to the literal meaning. Vehicles meaning everything we might call a vehicle, which could include, depending on how you interpret vehicle, bicycles. Maybe a vehicle would include a bicycle, but maybe in this context, linguistic canon, a usum generis, which means that catch-alls at the end of a list aren't meant to be interpreted literally. Instead, they're meant to be restricted by the context provided by the list of things. And so, of course, this canon might be valid, and I would argue it is valid. I was part of a team that conducted research and tested how ordinary people use language. Usum generis, I would argue, is valid, but it doesn't point in any kind of determinative way to any one outcome. You still have to use context. And Justice Scalia called the usum generis, along with some other canons, contextual canons, which means two things. One is that it can't provide you with a definitive way to interpret context in any instance. And the second important part is that these are just presumptions, right? That's how language works. And so you have to keep in mind that in some situations, maybe I would argue a minority of situations, but in some situations, the presumption created by the canon is canceled, right? And so sometimes the literal meaning is a correct meaning. So you have a canon that I would argue isn't determinative. It doesn't point to any one conclusion in any kind of narrow way, leading to criticisms, like perennial criticisms, right? But I would argue that's not the right way to look at canons, that linguistic canons are really useful because if they're valid, they give the judge important information and they guide and narrow the judge's analysis. And they make legal interpretation much more predictable, right? And they're a much more sophisticated way to analyze context and to make sense of it. 2 minutes, oh, all right. That was too long. And the two ways to kind of view canons that Benjamin talks about, an efficacy way and a probabilistic way. And your paper is really provocative, and I like this idea of thinking about efficacy. But I would argue that a canon is really worthless unless it's valid, unless we can know by consulting the canon that it represents some kind of majority way, some systematic way that people use language. If it doesn't do that, if it just reminds us of some possible way to use language, I'm not sure that's so useful if this possible way is some minority way. Without some additional evidence that, well, this minority way is applicable in certain circumstances that we can identify and not applicable in other circumstances that we can identify. All right. And I would argue also that a real problem with canons like expressio unius is that they're too general, right? And so I would argue more work needs to be done with linguistic canons to narrow them and maybe create more. I think the generality is a large reason why they're not all that useful sometimes and why they're also heavily criticized. But I really like the work, and I'm sure what you're going to do in the future. So thank you.
Awesome. For anyone who has questions, we're going to present all three papers and then do some questions from this group, so hold your fire for the moment. Rob.
All right. 14 years ago, Steve Vladek asked on Prof's blog, must Second Amendment originalism account for the militia clauses? I thought that was a fair question and that I should try to answer it. Little did I know it would take 4 papers and spread across 5 years of my professional life. The paper that I'm presenting is the third in the series, where I set about to connect the Second Amendment back to the militia. My paper seeks to rehabilitate and defend what was once the standard theory of the Second Amendment, that it secures at least an individual right to keep and bear arms for common defense. And notice that I say it secures. The right to bear arms was a right recognized at general law before the adoption of the Constitution. Blackstone listed it, for example, among the auxiliary rights of Englishmen. Originally, the Second Amendment secured the right only against the national government, and various state constitutions also declared the right, protecting it against state governments. But it is important not to anachronistically understand these various right to bear arms as separate legislation protecting different rights. As 19th century state courts repeatedly explained, all these provisions were declaring the same basic fundamental right. And I think that the individual right for common defense view that I lay out does the best job not only of explaining the Second Amendment, but also contemporaneous state constitutional provisions that protected the right to bear arms. All right, so what does the right protect? At a minimum, it protects the right to possess common military arms in the home, to carry them for training and public defense, and incidental rights necessary to make these rights effective, such as the right to purchase arms and ammunition. Now, I only have 10 minutes to speak, and I have a lot to say, so I can't flesh out this claim with extraordinary specificity. Although, in fairness, I don't do it in the paper either. Serious discussions about the right to bear arms have a way of getting sidetracked by arguments that if the right possesses military-type arms, then it will secure the right to own tanks, missiles, cannons, nuclear weapons, and that because this is absurd, the underlying theory is also absurd. I don't think the validity of the theory is so facilely defeated, but let me give, in any event, two brief responses to this criticism that comes up almost immediately. First, although this theory claims that the arms protected by the Second Amendment includes military weapons, the theory does not contend that the Second Amendment protects all types of military arms. In more formal logical language, the theory denies the truth of the following conditional. If a weapon is military equipment, then it is constitutionally protected. Instead, constitutionally protected arms are a narrower subset of military weapons. Those, as courts have said, those that are usually employed by individual soldiers during civilized warfare and for the other purposes of the militia, to enforce the laws and suppress insurrections. Second, the individual right for common defense theory does not subscribe to the claim that if an arm is constitutionally protected, then it is beyond all legislative regulation. Although constitutionally protected arms and their accessories may not be banned, they may still be regulated for public safety. For example, legislatures may require that rifles have a reasonable barrel length, minimum barrel length. Short-barreled weapons are simultaneously less adapted to public defense because they lose accuracy and range, and more useful for criminal activity because they are easier to conceal. Judd's going to talk in a minute, and I lack a right of response, so I'm going to invoke the Bush Doctrine here and try to preempt a little bit. I think in principle, Judd agrees with the broad outline of this, that there is a right and it's subject to reasonable regulation. I will say, though, I think in practice, my understanding of what constitutes reasonable regulation is narrower than Judd's, although I don't, since I'm preempting, maybe that will be unjustified. But a restriction on a right is not reasonable when it destroys the right's fundamental purpose. And that is why it's important to understand that a core purpose of the Second Amendment is to reserve some military capacity in the citizenry. If you examine the right solely as a right for individual self-defense against crime, then it is easy to uphold, as many courts have done, the validity of laws, for example, that prohibit certain kinds of assault weapons, because such bans leave a plethora of other weapons entirely sufficient for personal self-defense. On the other hand, if the purpose of the right is to ensure that citizens can prepare for and participate in military service, then such bans are constitutionally problematic because they target a class of weapons because of their usefulness for military purposes. So the right and the purpose hang together. Now, the general theory that the Second Amendment protects an individual right for common defense has been around since the beginning of the Republic. 19th century scholars and judges debated whether individual self-defense against crime was additionally protected. But no one doubted that the amendment reserves some military capacity to private citizens, so I can't claim any novelty there. But I still think there are at least two critical contributions that the paper is making. First, the article attempts to do some heavy conceptual cleanup. The literature has been imprecise in how to distinguish, for example, an individual right from a collective right. Justice Stevens, in his Heller dissent, purports to agree that the Second Amendment secures an individual right of some kind. I disagree, of course, with Justice Stevens's characterization of his own theory. And I argue in the paper that what distinguishes collective rights theories from individual rights theories is the belief that citizens must satisfy two conditions precedent to be vested with the right to bear arms. The first is having some form of prior governmental authorization. The second is necessity, that individuals only have a right to keep and bear those arms necessary to perform their official duties. Individual rights theories, in contrast, deny that individuals must fulfill these conditions precedent before being vested with the right. And consequently, there are really two species of individual right. First, an individual right that enables personal self-defense against crime, and second, an individual right that provides for common defense by enabling resistance to invasion or oppression. And it's important to analytically separate the first theory from the second. An individual right for common defense is compatible with an individual self-defense view, but it does not entail it. Separating the first and second theories also explains why many collective rights arguments are non sequiturs. For example, Justice Stevens purported to deny the individual right by rejecting Justice Scalia's focus on individual self-defense. But the denial that the right to bear arms protects private self-defense against crime does not establish the truth that the right is conditioned upon prior enrollment in the militia. Second, this article grounds the right to bear arms in the amateur military tradition, not in military federalism. Collective rights theorists frequently argue that the Second Amendment is a federalism provision that secures a state's right to military forces against fears of a national standing army. Indeed, underneath Vladek's inquiry was his claim that the militia for constitutional purposes has basically become a dead letter. Here I think Justice Stevens is mistaken and Professor Vladek has confused two different things. Second Amendment debates perpetually confound state armies with non-professional armies. A militia is not a state army. The essential attribute of the militia was that it comprised citizens with civilian occupations who could be called into temporary military service. And it stood in contrast to an army of regular soldiers, those whose principal occupation was warfare. Framing era objections were not leveled against national armies. They were leveled against standing armies. The framers feared armed factions in society. The Second Amendment protects citizens against armed factions, not, as the collective rights view believes, armed factions against legislation by its citizens. The modern armies are what today we would call the regular components of the non-naval armed forces. In contrast, the modern instantiations of the militia are the military reserve forces, the National Guard, and the selective service system, all of which organize citizens for temporary military service. Importantly, one should not confuse, as Vladek did, Congress's efforts to label these forces as part of the armies, a legal fiction purely designed to circumvent constitutional restrictions on federal power over the militia, with the claim that the militia as an institution has ceased to exist. At bottom, the individual right for collective defense theory recognizes that the Second Amendment secures the institution of amateur soldiery, an institution that remains alive and well. The existence of amateur soldiery and the keeping of regular forces to the minimum size necessary for national defense are critical components of preserving civilian control of the military while maintaining adequate national defense. Ultimately, the Second Amendment's importance in preserving the amateur military tradition is not diminished by the federal government's seizure of operational control over amateur forces from state governments.
Thank you, Jed.
All right, great. Thanks so much. So I really enjoyed this. I always learn a lot from reading Robert's papers. Last paper that I read, I learned that I was a member of the unorganized Virginia militia, to which my response was that it was indeed quite unorganized. And it's a really cool line of work. Robert is not entering this debate by just talking about the same tired Second Amendment problems. He's actually got a broader agenda where he's interested in the division in other ways between militias and armies. And so he's bringing to bear on the Second Amendment question, one that's been debated heavily, a kind of deep knowledge of immensely relevant but maybe understudied aspect of the Constitution, the division between armies and militias. I'm going to just say at the outset that I agree with the central thrust of the two key claims. The primary undergirding function of the Second Amendment and the right that underlay it was related to the militia. And secondly, that it recognizes some form of individual right. And I'll just comment on 4 areas where I think the paper could potentially improve. First is, and this is generalizable to all con law scholarship, I think it could be a bit more straightforward in presenting its underlying jurisprudential assumptions. And so there are times at the paper where I'm just not entirely sure why the evidence is being brought to bear on what question is being asked. And so, for instance, lots and lots of the paper is about 18th century ratification debates. That all seems immediately relevant to the question of original meaning. And then lots of the paper is about 19th century evidence, including at some really key points, like a point where Robert says, and the members of, the holders of this right were not just members of the militia, but all citizens. See Thomas Cooley's 1880 treatise. And it'd be nice to know why that evidence is relevant to what claim you're trying to defend. Because if it's a claim about original meaning, I don't think it's particularly valid evidence. But if it's a claim about a kind of general law right that evolves over time that we can get a better grasp of by looking to 19th century evidence, then I think that has a lot more purchase. Kind of along those lines, my second comment is I'm not entirely sure how we are going to cash out exactly who it is that enjoys this right and what the extent of state regulatory authority is. So absent the Thomas Cooley treatise, if what we're interested in is in how folks in the 18th century thought about this right, the paper doesn't offer us much direct evidence, if any direct evidence, about exactly how the right would play out on the ground. Like, why is it that the right would extend not just to members of the militia, but to other people in society? And the primary way in which Robert defends that application is functional. That is to say, there's an underlying goal behind the right, and that goal is best served by extending the right to others. And I'd just like to know the extent to which the arguments that you're trying to make along those lines are arguments about how people at a particular moment in time thought about the link between the function and the way in which the right was cashed out, and how much the arguments are actually based on your functional analysis of the link between the underlying function and what you think the right cashes out at. And I think that would help me better understand, getting back to the first point, sort of the extent to which you're making an argument that is fundamentally historical in character, and the extent to which you're making an argument that is drawing on other sorts of modes of reasoning. The third point is, and this gets to the comment that Robert made towards the end about federalism, I think that Robert's point in trying to differentiate between the difference between standing armies and militias on the one hand, and questions about federal power on the other hand, is both helpful and also kind of unfair to the people who have engaged in those debates. So I think it's helpful in the sense that there is a possibility of analytically separating out those two issues. And it would actually be quite helpful for us to understand the extent to which the right is premised on a concern about civilian versus professional control, as opposed to, or in addition to, a division of authority between the federal and state government. So I think that's very helpful. But I think it's a bit unfair to the scholars who've engaged in this debate because, in fact, historically, these two issues were deeply interwoven. So even at the state level, like Shays' rebellion debates, the concern about militia control was largely about local versus centralized control. Are we going to give authority to a central authority, or are we going to give authority to a bunch of rural folks who might use their local control to resist that central authority? So even though there's not like kind of conventional federalism story there, it's very much about local versus central control, just as debates about the militia versus standing army or about juries during the Revolution were about imperial versus local control. And then that same perspective informs the anti-federalist concerns about a militia, which is not to say that the anti-federalists think it's okay to have a state standing army, but they're especially concerned about having a centralized authority that has the ability to create a standing army, because they think that you can't have true representative governance in a large republic. So when you're delegating power to a centralized authority, you are giving over power to somebody else. You're not retaining power yourself, and therefore you're losing the central mechanism by which you protect your rights, which is self-governance. So at the state level, we don't need constitutional bans on standing armies because we represent ourselves. We are in control of our own rights. And the fundamental position of the anti-federalists is, if we create this new centralized government, it is too big, it's too unrepresentative, and so the basic way in which we traditionally preserve our rights is going to be lost. And so I think they are especially concerned about the issue of the standing army, not just from the question of professionalization, but informed by their kind of broader critique of consolidation. And then the last point is one that Robert doesn't specifically mention in his remarks, but that does run throughout the paper, which is his reading of Heller in relation to how other people have read Heller. So Robert is very dismissive of the idea that Heller rejects his position and instead reads Heller to be open to the possibility of a reading of the Second Amendment that embraces not just a self-defense interest, but also a reading that is informed by concerns about the militia. And I'll just say here, that's not how I have conventionally understood Heller. It's not how the case law has conventionally understood Heller. And I think that if you're going to be as critical in the paper about that reading of Heller, you need to back it up. You need to provide the receipts, give us a kind of deeper sense of why it is out of Heller that you think that reading is not the kind of self-defense only reading is not required, not as a matter of logic, I agree with you on that, but just as a matter of what Justice Scalia was up to in that case. So thanks so much.
Thank you. Tyler.
Yeah, thank you, everyone. Thanks for coming and for being here. I'll start off with a little bit. We're going to travel back in time a little bit, give a little bit of a historical context, so I think it's necessary to understand, but we will get back to modern day. This paper is also about modern day. So a statute from 1871, known as Section 1983 today, is kind of the primary means for obtaining money damages against state officials, particularly for constitutional violations. However, for the first 9 decades after its enactment, it produced only a couple dozen reported decisions, many of which just merely refer to Section 1983 as kind of the procedural posture without really discussing it at all. But in 1961, that changes. In Monroe v. Pape, the Supreme Court explicitly held that a Section 1983 claim, as it understood it, would lie even when the state law prohibited the state official's actions, and even when state law gave a remedy to the victim against the state official. Since then, Section 1983 claims have skyrocketed. The most recent data indicates that there are about 15,000 suits filed under Section 1983 each year. Many of those are from prisoners, but not all, and that has been slightly diminished since some of the reform to prisoner litigation. But Section 1983 has still remained essentially untouched since 1871. So it now reads, paraphrased a little bit, every person who, under color of state law, subjects or causes to be subjected any person subject to that state's jurisdiction to the deprivation of any constitutional rights shall be liable to the person injured in an action at law, suit in equity, or other proper proceeding for redress. And so as reflected in Monroe v. Pape, the conventional wisdom, indeed near unanimous wisdom, is that this section creates a federal cause of action. But of course, the statute, as we just read, gives essentially no rules for this cause of action or no guidance to it. And so here, the wisdom does divide a little bit. Judicial precedent and the dominant view says that for this supposed cause of action, the understanding and in congressional intent was that well-settled common law rules of 1871 would kind of fill those gaps, would plug the gaps, governing the most analogous torts to whatever the constitutional violation is. Some scholarship, especially recently, has claimed that the Section 1983's kind of shall be liable statement creates full and unconditional liability. But the predominant theory still is that of this 1871 common law rules. However, that conclusion, I think, comes with some difficulties as well. 1871 tort law doesn't really align with modern, or 1871 for that matter, constitutional law. And 1871 tort law had specific rules. If you're going to look for the well-settled rules, the rules varied based on who the defendant was, including specifically for state officials. But to courts today say, well, the relevant defendant, when we're looking at these tort rules, is a private tort suit against a private individual. But again, that's hard to kind of map onto a Section 1983 suit. And then even then, once the court has identified the relevant common law rule, it's unclear how that rule interacts with the constitutional violation. Does it provide an additional barrier for remedy? Does it work in tandem? When does the constitutional kind of substance overcome those common law rules? And these disputes, I think, have come up most prominently in questions of official immunity, qualified immunity for police officers, absolute immunity for prosecutors. But they also have came up recently in kind of what are the damages for this suit, for a suit alleging an unconstitutional arrest warrant? What's the causation requirement for retaliatory arrest, particularly under the First Amendment, where their malice is a precondition to recover for some Fourth Amendment violations, even though it's not a precondition for whether there was a Fourth Amendment violation in the first place. And so I think, though, the courts have worked on this, and the common law approach with some refinements and nuance, and this is going around in the lower courts mostly, might be able to make sense and make a coherent system. But I think that then you look back at the text and you look back at the drafting history and the debates about Section 1983, and it seems unlikely that such a convoluted approach would have came out of such a simple textual and uncontroversial textual provision. However, an unconditional liability regime, on the other hand, I think seems to make almost less sense, right? No cause of action imposes liability unconditionally, especially one that didn't receive much debate. So what is missing? I think what we're missing is that 1871 was a much different legal world, and I think this has been touched on by kind of the debates about the Second Amendment as well. And we start off, for me, which is as relevant to Section 1983, in the late 18th and early 19th century, causes of action were generally not understood by reference to the substantive right. It was kind of a trans-substantive cause of action, but rather by the forms of action plaintiffs would have to use at actions at law. So think about writ of trespass and action on the case. And then these forms of action, once the plaintiff used them, dictated the parties that needed to be a part of the suit, the causation requirements, the remedy, many other features of a cause of action. Professor Belia said its own kind of mini civil procedure system for each form of action. And so a plaintiff seeking to bring any claim at that time would have had to identify a substantive right, allege and eventually approve a violation of that right, but then fit that fact pattern into a particular form of action and bring that form of action. So these actions, which define the cause of action, were defined by local law. So when federal courts were created in the early republic, Congress could have kind of created its own system of forms of action, but instead, Congress, through the Process Acts, directed federal courts to use local state law forms of action in the state in which they sat, and then locked those forms of action in 1792. So even throughout the 19th century and through the 1800s, federal courts were using state law forms of action, causes of action, from 1792. And then state substantive law would apply to these causes of action, absent a directly contradictory federal statute. So I think in this context then we can kind of understand better the original effect of Section 1983. plaintiffs still would have needed a state law form of action. The Process Act was unconditional, and when Congress wanted to deviate from that choice, it did so clearly, as it did in other sections in the same act that Section 1983 was included in. So Section 1983 provided liability in federal court, but that liability was specified to be in an action at law, and actions at law were state law forms of action that were subject to the same defenses and affirmative requirements that non-preempted state law would have imposed. So Senator Thurman in the debates says of Section 1983, it creates no new cause of action. Its whole effect is to give the federal judiciary that which now does not belong to it. In 1890, a circuit judge observed that Section 1983 did not change the rules of pleading or the mode of proceeding, which was another way of referring to a form of action. In any respect, he said no new mode of proceeding was enacted and no new right created. Okay, so even if that's kind of the more historical part, historical context, so even if you're up to me here, we obviously don't live in 1871's legal world. We don't have forms of action. We don't use state law forms of action. What does that mean for us now? And I think that the thrust of this paper is, perhaps surprisingly, these later legal changes have only minimally changed what would have happened. So originally in 1871, federal courts would have had to look to 1792 causes of action, state law causes of action, and then looked to on substantive rules that were not related to the constitutional violation or the form of action, would have looked to modern state law. But today, courts should look to modern state law causes of action and modern non-preempted state law. So, take for example, I'll just go through one of these. There's lots of legal changes, but one is the Rules Enabling Act and the Federal Rules of Civil Procedure, obviously, which did away with reference to state law for forms of action, and more generally, kind of pleading rules. That change meant that federal courts no longer looked to state law, but the Rules Enabling Act specifically said that it did not affect any substantive rights, as understood in 1934, which means that it wouldn't have created any kind of causes of action or entitlements to remedy that didn't previously exist. Professor Blee, again, has said how he phrases it as a post-Rules Enabling Act. Federal courts still relied on state law to determine the causes of action available for the violation of federal statutes, because causes of action were now viewed as substantive, and therefore, under the rules of Erie, we still look to state law. And then I think the elephant in the room, obviously, and the most difficult hurdle, the one that I'm the most uneasy about in my paper, is obviously stare decisis, okay? So Monroe v. Pape in 1961, kind of the first decision along these lines, but many obviously have treated Section 1983 as a cause of action, and that's obviously the very dominant wisdom. But I think even the modern stare decisis test, and for statutory stare decisis, doesn't counsel maintaining precedent. I think in light of the context and the specific statutory requirement, the federal courts were to look to state law causes of action. The current interpretation of Section 1983 is egregiously wrong. I haven't understood how one would deal with the Process Acts and the requirement to look to state law causes of action. Also, the reasoning I don't think has ever been fully developed. In Section 1980, in Monroe v. Pape in 1961, both the majority and the dissent either assumed or just stated it was so without any reasoning, and other decisions have done the same. I think the other key is that it's proved somewhat unworkable, as we discussed earlier, and there's others who have kind of talked about this tension, Garrett West and James Fander have, about this kind of disconnect between 1871 private tort law and constitutional torts. And I think it's been kind of undermined by subsequent precedent, which generally more focuses on text and context and disfavors reading in implied causes of action. So that's my paper, and I ran out of time. I apologize. I did not start my timer, so that was unhelpful to have my phone here. Thank you.
Tara.
All right. Thanks so much. Really, really fascinating stuff. Very creative, very provocative. And there's a lot going on in this paper. There's also a really interesting discussion that Tyler didn't have a chance to talk about, sort of in the second half of the paper, about stare decisis and what do you do with something that's sort of been a legal assumption underlying an entire legal regime but never explicitly stated. Does that get stare decisis effect? So really, really fascinating stuff. I have a bunch of comments. So the first thing is there's just so much going on in this paper. And so I feel like this is, I know you have another paper on Section 1983, and I think you're building on that, but I wonder if maybe you should build this out into multiple papers, because you've got this big historical claim, right, that we completely misunderstood Section 1983 as creating a federal cause of action. And then you say, well, this has implications for qualified immunity and Monell and the meaning of state and the meaning of person in Section 1983. And there's like a huge literature on all of those things. And so one thing you might think about is focusing on the historical claim. I have more on that in this paper, and some of the implications as to how this cashes out in treating these things as state law claims, and then following up in subsequent papers about what this means for the qualified immunity debate, what this means for Monell. So that's just one thing to think about. And I'll just say in general, whenever you're a junior scholar and a senior scholar says, hey, this could be more than one paper, that's actually a good thing. It never feels like a good thing when you're hearing it, but more is always better pre-tenure. So this could be a good thing if you agree with me. And by the way, I'd like to see a future paper on what your reading of Section 1983 means for the Prizer-Heck doctrine. That is the relationship between habeas and Section 1983, because that struck me as potentially interesting, but not something you should deal with in this paper. So on the historical claim, you're fighting against a huge, huge headwind, right? So all of the justices in Monroe v. Pape, pretty much all scholars, all political stripes, coming from all sorts of different directions, all sorts of methodologies, have believed that Section 1983 created a federal cause of action. It doesn't mean that's necessarily right. I think you make a claim that is plausible in light of the text of Section 1983, but boy, oh boy, do you have a heavy burden. And so I just wanted so much more on the history side. I felt like the history section was really thin, and then you jump into this really fascinating discussion about stare decisis, but I wanted to see lots of stuff from the legislative debates in Section 1983. I wanted to see stuff from maybe treatises, legal literature around the time. Really, one of the points you make, I think accurately, is when you're dealing with history, you really do have to try to immerse yourself in the historical context of the time. But I don't feel like you do that for the reader. So I think you could have a whole paper on the history, and I think you're building on your prior paper, right? But I think there just could be a lot more. And this of course relates to whether this is egregiously wrong. But it's not even clear to me that it's wrong, like our prior assumptions based on what you've given me so far. And you mentioned some stuff in your talk that would be more specific, like statements by legislators at the time. But I just think you need a lot more of that. Next comment. I was puzzled at the end that you said your story was consistent, and I love that Judd's on this panel, with the general law theory of folks like Judd and Will Bode and Steve Sachs. So as I understand their assertion, the 14th Amendment was deemed, at least in part, to embody general law principles that applied nationally. And were just understood in our system. And Judd knows how I feel about ideas of general law, but there's a lot to that theory, right, as an understanding of the 14th Amendment. And your argument strikes me as very much at odds with that notion, because what you're telling us is that Section 1983 incorporates state law causes of action in the modern sense, right, incorporates current state law causes of action, which means that we do not have a body of principles that apply nationally. Instead, we have state law causes of action that are going to differ from New York to Texas to Pennsylvania and so on. And you're also talking about very much positive law, right? Like, this is a post-Erie legal realist theory that you are presenting, right? That where states have complete control over their law, where federal courts have to defer to state courts as to the meaning of state law. Federal courts cannot identify general principles independently, rather they're just, state courts are in charge. This is a very Erie-friendly paper, but that strikes me as very much in tension with what I think the general law theory is doing. I'm not saying I disagree. I'm I'm trying to hold tight to Erie as people attack it, but I think that's tough to reconcile. I also wonder if your paper is really actually that consistent with Monroe v. Pape. So one of the things that Tyler argues is there's a narrow holding of Monroe v. Pape, pretty important, that people bringing claims under Section 1983 do not have to exhaust those claims in state court first. Frankfurter said they do. The majority opinion says, no, you don't have to exhaust. But given all of the things in your paper about the importance of state law causes of action, the importance of state courts, you argue that contrary to what most of us think, the Reconstruction Congress had a really high view of state courts. It would seem to me that Justice Frankfurter was right in Monroe v. Pape, that actually you do have to go to state court and see what they do with your claims before you come to federal court. At least I think it's worth mentioning that there's a potential issue here. And just a couple of smaller things. In your talk and in the abstract of your paper, you refer to non-preempted state law, and it wasn't clear to me what that meant. It's possible you're talking about like just direct preemption. Congress could change the statute of limitations or not. That may be what you mean. But when you referred to this a few times, I thought, like, is it possible that there are some kinds of state laws that are just at odds with the notion of a constitutional enforcement under Section 1983? And so fleshing that out would be helpful. And the final thing I'll say, and I'll send these comments to you. The final thing I'll say here is I found myself at the beginning of your paper wondering, well, what does Section 1983 do then? If it's just a bunch of state law causes of action that people presumably could already bring, is it just a jurisdictional requirement? And it wasn't until page 22 that you said, yes, this is granting federal jurisdiction to federal courts. And I felt like that needed to come a lot sooner. So these are awesome thoughts. Again, fascinating paper, and it just kind of blew my mind in terms of what this would mean.
All right. Thank you so much. Now we're going to begin approximately 15 minutes of chaos, where if you have questions for any of the panelists, please come to the front. And if there's some quietness, feel free to, engage in crosstalk and just reply to each other and all of that. So start with Ilan.
Great. Well, this was really, really fantastic. I learned a lot from all this. Seeing just Bradley up here, can I ask each of them a question, or am I only
just
limited?
be brief.
Okay. So, Benjamin, so my question for you is, I think this is what Brian was trying to get out with his truncated comments, but it seems actually that what you're saying is it's really good that we have these canons. They do a lot of work because they accurately reflect how people use language, which is good to keep judges in check, because judges otherwise will say crazy things like a tangible object is a fish, when in fact we all know it's related to documents and records and things like that, and ordinary people. So it's a check on judges. So it does seem to do work. I was surprised by the use of generis. Is that your view? Is that, or are you going to push, or do you have a pushback on that? But that seemed to be the work that you were doing. Tyler, my question for you is, isn't the work, if Frankfurter was right, what you said at the beginning, that really the whole point of this was only to create a liability against state officers acting pursuant to state law. They're actually authorized by the state to do this. If that original understanding were kept intact, what work would it do to say, or not, that it's a federal cause of action as opposed to something else? In other words, hasn't 1983 gone out of control because we hold state officers liable when they exceed authority under state law, which wasn't the point? What work does it do to call it a cause of action versus something else? How would the world be different in that respect? I didn't quite follow that. Robert, my question for you is a little orthogonal. I just also want to plug Robert's papers on this, his first two, are just really, really excellent. And actually, Robert, I just want to tell you, you've really changed how I thought about the Second Amendment. And, because there's, well, anyway, read his other papers, they're very good. But my question is, might this all have nothing whatsoever to do with the militia? And here is, I guess, two possibilities. One is just like, I've thought of this, I haven't seen anyone, there's no proof of this, there's no silver bullet. But there's a reason why Madison might have included the militia, the prefatory clause in there, which is really just a Ninth Amendment problem, right? If the militia clause wasn't there, that might raise the implication, where does Congress get the power even to infringe on the right to bear arms? That might, again, create this inference that Congress has enlarged powers or that it might otherwise have had this power. The only connection is the militia, and so let's just say that. to make sure that no one gets the wrong idea that Congress has any power over arms beyond the militia. So really the militia is irrelevant, other than just to keep this Ninth Amendment rule of construction. The other thing while I have you is, I know I emailed with you about this, but I had a former student of mine at my former institution wrote a paper under my supervision, which really unearthed a distinction, which I think you had said you hadn't seen before, that there's a distinction, at least a contemporary distinction, between arms and ordnance. And so I asked ChatGPT just while I was listening to you talk, and I'm not going to pull it out because Christina's going to get angry at me.
Short question.
But ChatGPT is pretty good. And it says arms are personal things that you can carry, like small munitions and so on. And ordnances are tanks, artillery, cannons, things like that. So the Second Amendment, preserves the right to keep and bear arms, not ordnance. Maybe it wasn't. I don't know. Is ChatGPT trained on the BYU corpora, of early America? I have no idea. But both are possibilities that suggest the militia has actually absolutely nothing to do with it. Thank you for your indulgence.
Anyone want to go?
Maybe I'll just go first. I'll be very brief. It is a good point, right? But canons really cannot constrain, right? Because they're not even presumptions. They just suggest readings, and it's very easy to dismiss these readings. So that's the first point. And the second point is the absence of a canon. It doesn't foreclose an argument based on ordinary meaning, right? Just because there isn't a canon doesn't mean you can't argue a certain point about the ordinary meaning of language. So that's my very brief response.
I think on the second item, let me do the second item first. On the second item, I'm genuinely not sure, and I don't take my paper to be laying out a full treatise on what the arms are. I think further research can come in here, of which your students' research may be very helpful. On the militia clause, I would be very surprised if it were irrelevant to the right to bear arms. Madison's original draft first said that the right to keep and bear arms shall not be infringed, put the provision in about the militia being necessary to the best security of a free country, and then added, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. So when you look at Madison's original draft, they all three seem to be aimed at military service, and I would be surprised if the first had nothing to do with the second. What I think the prefatory clause was doing was throwing a bone to the anti-federalists who wanted a declaration that standing armies are dangerous to liberty, without saying that because it would have offended the Federalists, many of whom were Revolutionary War veterans.
Yeah, so on whether Frankfurter's right about under color of law and what's really doing the work here. So on a side note, I think that Frankfurter's wrong about under color of law, and that actually under color of law included violations of state law as well. But even if we kind of set that aside, his world in which we bring a Section 1983 claim when state law is also violated still presents these same difficulties. Maybe there's not 15,000 suits a year, but we still have the same difficulties of, well, what rules govern those kinds of that cause of action? Are there any defenses? What's the nature of liability? And this kind of comes back to kind of maybe something that I need to clear up in my paper that Tara mentioned about, I think Reconstruction Congress was very distrusting of state courts. I just don't think that distrust extended to state legislatures and state substantive law. And so I think, the work is doing is that plaintiffs should not have to go to state court for these claims at all. And so they just come directly into federal court. And so I think that's kind of the work that's what's doing. Also why Frankfurter is wrong, but it does work regardless. It's just a smaller subset of cases.
Bradley?
Yeah, so I promise to be briefer than Elon was. I have just two questions for Robert and for Benjamin. Robert, mine's very straightforward for you. So just on your operative theory then of the Second Amendment, I'm just curious, does then what our standing army reserves, I don't know, what the ordinary weaponry is, right, for infantry, is that like a constitutional or like a regulatory floor right, for what states can and cannot regulate then moving forward? I'm just curious how that works. And then for Benjamin, this might sound like a weird question, but I was training political science. You mentioned randomized tests. So I'm curious what exactly you controlled for in your random experiment. Did you control for education, and what kind of education people receive? Like what kind of degrees? It strikes me that that matters, but I'm curious if you controlled for those things in your outcomes.
I think the answer to your question is yes, that the Second Amendment in a way functions as a kind of equal protection clause between civilians and the professional military to prevent a kind of disparity of force between the two. Now, it's still subject to reasonable regulation, so I don't want to say that anything exactly in a military configuration is the floor. There may be some regulation that's permissible a little bit beyond that, but I think in general the answer to your question is yes.
I'll just answer the methods question. There's randomization, so in some sense, I don't put in any controls. Because if there's randomization, people randomize to one group and people randomize to the other group, they're exchangeable. So you can kind of treat them as having having the same covariates. After the fact, we can look at heterogeneity, but I haven't done that. I didn't pre-register that. But that's a good idea. That's something I could look at. Yeah.
Thanks, this is all really interesting. I had a question also for Robert and Benjamin. So for Robert, I was curious about the implications of your theory for what regulations are allowed, because I would think if I understood correctly, it would sort of shift the terms from, whether the weapon is useful for self-defense to whether it's kind of useful in a military context, sort of answers that question, but then by the same token, presumably what regulations would be allowed would be those that would apply to excluding someone from military service. So, for example, it might make the assault weapons ban question easier, but something like felon dispossession is potentially hard under the self-defense theory, but might be easy under your theory, if I've understood it correctly. In other words, if you could exclude someone from militia service based on criminal conviction, would that carry forward today to say, so the focus of what regulation is allowed should be, who would have been excludable from militia service, and what would that imply, if that's right, if I understood correctly. And then for Benjamin, I think this overlaps with what Brian was getting at, but I tend to think of these canons as being most useful in sort of dealing with statutes that are very non-intuitive. You're dealing with some technical regulatory area, and the point is to kind of pull an intuition out of ordinary language and use it to make sure you're approaching this technical thing the same way. And so if that's right, then I wondered, it sounded like in your experimental design, the examples are pretty intuitive, like kind of napkins and stuff. So is that really helpful if that's what the point of having the canons is to like make sure you're approaching non-intuitive language in the same way you would approach intuitive language? Are you really getting at that with the type of examples you're using?
So in terms of the implications of the theory, I think a first question before you answer that is whether the individual right for common defense is the exclusive purpose or one of two purposes. I deliberately bracket that question. I think that was the primary 19th century question when the cases disagreed. If it is both individual and collective self-defense, then the Heller line is fine, but on top of it, there are restrictions on things like prohibiting the possession of military arms. If you take the civic Republican view that the common defense view is the exclusive purpose, it flips the right around a bit. So the individual possession in the home of military type arms is the core protection at that point. But public carry of handguns, let's say Bruin, might very well either fall outside the right or be subject to much more regulation than the court allowed in Bruin. I disagree with the idea that if you can exclude somebody from militia service, then you can deprive them of arms. And I note in the paper that the age restriction, the statutory age restrictions, and then there's sex restrictions on the militia are arbitrary and subject to revision by Congress. And so just because 45 is the maximum age of militia service today doesn't mean it would be the maximum age in the future. And so the amendment goes more broadly than any particular statutory choice in a point in time of how to define the militia.
So thank you. Great question. Actually, the position you just sketched is also the position I defend in the paper. But as to the experiment, it's hard to say what's technical, right? So the example of napkins and tableware, that came out of the tax code. And so in some sense, the tax code is technical. But where I think canons might be useful is when there is a kind of purpose, kind of contextual element to the rule that's not obvious on its face. Right? And then the paper argues basically a canon could kind of prompt you to think, okay, right, maybe I should look a little deeper, maybe I should look a little into other sources of meaning and see if that changes how I view the ordinary meaning of the text. So I'm not sure if I chose the best examples, but I'm not sure technicality is what the distinction is, right? It is this latent possibility, that text could be read in a different way if you knew something more about the context in which the text was written.
Thanks. Lee, and you're probably the last question based on the timer.
Okay. I just wanted to see if any of the paper authors had, something they wanted to say in response to the commenters.
I have a lot, but we're low on time.
Well, if we're low on time, I could maybe take one response at the risk of riding Judd's coattails and saying, yes, it's consistent with his view. Maybe just to take a response to why I think that my view of Section 1983 is still consistent with Judd's view is that my understanding of the general law theory of the 14th Amendment is that the substantive law of the 14th Amendment comes from general law, something that extends across jurisdictions. And what I'm saying is there is certain, that doesn't necessarily speak to the enforcement of that general law, and that forms of action were subject to local law and not general law at all. And so all I'm saying is that Congress in Section 1983 used the local law as a way to enforce this general law. And so, of course, the general law on the substantive constitutional provisions, when we're deciding if the state actor did violate the Constitution, we would still refer to more of the general law as reflected in the 14th Amendment, assuming that the general law of the 14th Amendment is correct, or just whatever the 14th Amendment means according to whatever the correct interpretive method is, and that the state law is more looking towards enforcement, but wouldn't define or kind of substitute the idea of the general law. But that was always understood that these rights, even before the 14th Amendment, their enforcement would have been kind of subject to state law. So that's how I view the consistency.
Okay, let me push back on one and maybe two things that Judd said. He said that my militia versus armies discussion was unfair because federalism and professionalism are intertwined. But I don't think it's that unfair. There were, in fact, bans on states having standing armies. It's in both federal constitutions, the Articles of Confederation and in Article 1, Section 10 of the U.S. Constitution. Not to mention that the Constitution of a lot of, if not most of the states, had declarations against standing armies. So this was not totally intertwined with the central power. The framers had pretty universally rejected the idea that state governments, even though there's local control, that state governments should be able to have professional forces. And in terms of being dismissive of Heller only having a self-defense reading, I think I would say two things. First of all, Heller never explicitly rejects that it is accepting the individual self-defense rule to the exclusion of public defense. To the contrary, it says that the right was for both public and private violence. And second, I think this kind of illustrates the danger of where modern Second Amendment jurisprudence has gone in treating Heller like it's some Talmudic text, that everything that relates to the Second Amendment must come from there. Heller was the court's first modern foray into the Second Amendment, but you can't elevate every dictum and every implication from the dictum into actual doctrine, especially where there was no party presentation. You have to judge individual cases on their own merits. And one of the things I think that the lower courts have massively erred on is saying, well, it's individual self-defense against crime to the exclusion of military purposes, such that individual self-defense weapons are protected, but public defense type weapons are not. I don't think there's any way to reconcile that with the original understanding of the Second Amendment.
If you want to say 20 seconds, I'll give it to you.
All right, 20 seconds. I think, Brian, thank you so much for the comments. I think the biggest challenge you raised to my argument is your suggestion that the probabilistic view of canons is possible. And I don't believe it's possible. I don't believe it's possible to have canons kind of summarize over a majority of cases what text means. And I can't prove it as a matter of logic, but I'll just give you one example. So walking in, I saw a sign. It says a badge is required at all times in the center. Security enforces policy. I know it's directed to me, and I think it means everyone has to have a badge. But if the sign said, a fire extinguisher is required in the center and security enforces policy, that sign is directed to security, right? And it doesn't mean everyone has to have a fire extinguisher. So I think language is so flexible and pliable. It's not possible to have canons actually summarize majority usage in any quantitative kind of way.
Wonderful. So we're going to thank this panel and reset for part 2. J.D. candidate at Stanford and Ph.D. candidate at Virginia, presenting his paper, A Council of Grand Strategists, the Original Hope, Fear, and Intent of the U.S. Senate in Foreign Affairs, with commentary by Keith Whittington from Yale. Our second paper is Sadie Blanchard from Notre Dame's Adjudicating ESG Reputation, with commentary by Robert Miller at Iowa. Afterwards, we will have about 10 minutes of questions and discussing replies. So take it away, Luke.
Thanks. Thanks, everyone, for being here. Appreciate the Federalist Society for hosting this panel, and, of course, to Professor Whittington for reviewing my paper and commenting on it. So my paper attempts to use constitutional history to answer a question that's raised by scholars of international relations. And it starts with a complaint that's common among analysts of U.S. foreign policy, which is the United States does not have a grand strategy. And colloquially, sometimes we talk about a grand strategy as if it's just a country's broad foreign policy, but a grand strategy differs from a foreign policy in important respects. First, a grand strategy is something that's long-term. It lasts decades, sometimes even endures centuries. Second, a grand strategy is oriented towards a country's most important foreign policy goals, meaning a country that has one will regularly prioritize vital interest over more peripheral ones. And lastly, a grand strategy is holistic, meaning it integrates all tools of national power, military, economic, and diplomatic, such that kind of all oars of the state are rowing in the same direction. And there's various explanations for why the US doesn't evince a grand strategy, but curiously, no one has yet posited the US Constitution as a reason. So in the first section of the paper, I kind of sketch out a theory of the relationship between constitutional arrangement and grand strategy. And I conclude that for better or worse, the US Constitution is not particularly conducive to grand strategy. Because the Constitution divides foreign policy powers, the various holders of those powers are unlikely to come to an agreement about what constitutes the nation's most important foreign policy goals. And without coming to that agreement, it's unlikely that those actors with their various tools are going to deploy them in a holistic fashion in a whole of government kind of way. And because the Constitution allows, indeed sometimes mandates, frequent changes in political leadership, office holders have incentives to privilege popular, urgent demands at the expense of more immediate, long-term or vital interests. So that's just a little of the background theory. The bulk of the paper really dives into the debates of the Constitutional Convention to explain how this very nearly was not the case. The constitutional historian Edward Corwin famously observed that the US Constitution is an invitation for the political branches to struggle over the privilege of directing American foreign policy. And it's true. As ratified, the Constitution does create that struggle. But that struggle was not the product of a deliberate choice, or so I argue. Instead, it's something like an accident that derives from compromises made at the convention. If we read Madison and Hamilton's Federalist Papers, where they seductively outline this elaborate system of checks and balances, a separation of powers, federalism, we may take for granted that that system was supposed to constrain foreign as well as domestic policymaking. But I argue that that was not the original hope of Madison, Hamilton, and other nationalists when they arrived in Philadelphia in May of 1787. Instead, they came to the convention with a plan for solving the foreign policy myopia, the provincialism, the volatility that they thought had so often sacrificed the national interest under the Articles of Confederation. They saw a need for grand strategy, and crucially, they saw in the Senate the promise of an institution that was going to be able to provide it. In fact, until the 11th hour of the convention, nearly all delegates assumed that the Senate would enjoy the near-exclusive power to run the nation's foreign affairs. Now, that vision of the Senate was lost to compromises made at the convention, and that vision has also largely been lost in historical accounts of what happened at the convention. So my paper attempts to recover what I call the nationalist original hope for a Senate that would run grand strategy, but also the anti-federalist original fear of that same specter, and finally the compromises that those two camps came to that form what we might today call the original intent for the US Senate and foreign affairs. At bottom, the nationalists sought to imbue the Senate with the qualities and vest the Senate with the authorities it would need to make and execute a long-term, holistic foreign policy focused on the nation's most important goals. So first, to facilitate a long-term foreign policy, the nationalists sought intuitively enough to give really long terms to senators. As Gouverneur Morris put it, by avoiding a change in men, the Senate would also avoid a change in measures. And by avoiding a change in measures, the Senate would earn the trust of foreign nations, which it sorely needed to secure everything from credit to trade to alliances to treaties. To attain stability and permanency, Hamilton urged delegates to provide for term lengths as lengthy as the Republican principles would admit. For Hamilton, for Morris, for Delaware's George Reed, that meant life tenure for senators. Of course, for other nationalists, the Republican principles were not as permissive, but still, folks like Madison and James Wilson thought 9-year terms was certainly not too long. Long terms would not only facilitate stability, but it would also insulate senators from popular pressures. encouraging them to privilege long-term vital interest over the more immediate and sometimes trivial concerns of a constituency. Anti-federalists like Martin Luther complained that senators with long terms without term limits would create this permanent body whose preferences would reflect the priorities of the seat of empire. To which the Federalists replied, that's precisely the point. Ultimately, of course, the convention landed on 6-year terms without term limits. It wasn't the nationalist hope, but it was quite the achievement when we consider that at the time, members of the Confederation Congress and state senators faced annual elections. Most of the state senators did. The nationalists knew, however, that long terms were no guarantee that senators would use their insulation to pursue important national objects over local ones. It mattered, of course, who the senators were, who selected the senators, and by what rule they'd be apportioned. The debates over first the mode of selecting senators and second, the scheme of representation that would prevail in the Senate, they were separate in theory but deeply entangled in practice because at issue in both was whether and to what extent state influence would pervade the chamber. Above all, the nationalists were determined to prevent the Senate from becoming what they called another edition of Congress, by which they meant the Confederation Congress, where each state enjoyed equal representation, and to the nationalist mind, the small states had exploited supermajority rules to hold hostage the national interest to parochial demands. The nationalists worried here that if states appointed the senators, senators would again become pawns of the state at the national capital. The nationalists had different visions for how best to select senators, but they agreed that so long as senators were elected by a popular constituency or nominated by the House or even appointed by the executive for lifetime seats, then the senators would be responsible to the nation at large and therefore stewards of the national interest. But once the convention decided that state legislatures would select senators, that the Senate would be a kind of federal concession in an otherwise national government, the nationalists knew they'd already lost their fight for proportional representation in the chamber because state-selected senators implied that the Senate would represent the states qua states. And to keep the Senate small enough for careful deliberation, which all nationalists agreed it needed to provide, while still giving the smallest state at least one seat, proportional representation was just impossible. So once the Connecticut Compromise was brokered, which provided for equal state suffrage in the Senate, Morris, Hamilton, and other nationalists wondered aloud whether it was worth retaining a Senate at all. Last, the nationalists hoped to holistically provide for a foreign policy that was integrated basically by handing all of the reins to the Senate. Until late in the convention, that position wasn't even controversial. On August 6, for instance, the Committee on Detail released its report, and that report assigned to the Senate unchecked authorities over each lever of national power. Militarily, the Senate would form alliances. Economically, it would negotiate commercial treaties, and diplomatically, it would appoint ambassadors and make peace. And that plan collapsed weeks later in September, less owing to anti-federalist pressure and more because the nationalists themselves soured on it. After they'd compromised on term lengths, on the selection method, and finally, now that the Senate would equally represent each state, Madison spoke for most nationalists when he complained that the Senate was now like Congress, the mere agents and advocates of state interest. And I argue that a close look at the machinations of the Committee on Postponed Matters, that committee that transferred from the Senate the power to appoint ambassadors and make treaties to the president, suggests that Madison and Morris used their seats on that committee to divest the Senate of foreign policy powers because they no longer trusted that that institution would pursue the national interest. In sum, the nationalists didn't get the Senate they wanted. There would be no Council of Grand Strategists and probably no grand strategy at all under the Constitution. In conclusion, in the paper, I suggest how the judiciary may be compensating for those compromises today, but I'll just leave it at that for now. Thanks.
Thank you. Keith.
Thanks, and thanks for the paper. It was interesting paper and interesting and sort of somewhat intriguing as a genre paper of thinking about paths that weren't taken and what an alternative version of the Constitution might have looked like, and potentially dramatic implications that might follow from that. I want to focus my attention, though, on sort of 4 suggestions for revisions as the paper continues to develop, moving from sort of least important to more important ultimately. So least important of all is, I found it somewhat awkward to refer to members of the convention as anti-federalists. You have a rationale as to why you use that language. I think it's an inappropriate language for talking about convention debates as opposed to those who oppose the Constitution and its ratification afterwards. I just found it awkward and confusing as a reference point, and I would urge you to find a different term to refer to that faction of delegates to the convention who were trying to resist these more nationalistic urges. And even the nationalistic urges, I don't think quite captures the sensibility of what's going on as you want to emphasize it, at least, but it works well enough for purpose of the paper. So secondly, also I think relatively unimportant, but maybe a little more so, is the ordering of the 3 components of the Senate. So one section of the paper sort of works through 3 components of the debates about the content of the Senate, what it's going to look like, the tenure of the senators, who they represent, and then what kinds of powers they exercise. And the powers comes last in that set, and I would reverse that and put the powers in front. In particular, it seems to me that there's a burden for the paper to highlight and emphasize the extent to which there was a vision for the Senate in which that was going to be the repository of foreign policy making in the constitutional system. And that sort of gets buried in the paper. And moreover, it's a pretty brief section of the paper. And I think if we're going to buy into this notion that there is some alternative constitution that could have been written such that the Senate was really going to be running the foreign policy show in ways that really minimize the significance of the presidency, for example, a lot more work needs to be done in order to really demonstrate that, build that vision up, and it needs to be more central to the paper and not sort of an afterthought of the paper, which the current, I think, organization of the paper sort of leaves it as a bit of an afterthought, but partially it's also just about how much substantive attention you give it. But I think I would start with that and then show why that, even though it's sort of, as you say, relatively late in the convention, that we sort of lose that component, and so there's a chronological element to having it there. But I think in terms of theme, it ought to be up front, and then we can see this is the vision that gets put forward, and then what's undermining that vision that leads us to abandon it, right? And then that gets you to then talking about the change of tenure, the term of office, and who they represent, et cetera. The third element I think that's worth thinking about in the paper really requires adding more to the paper, which is to say the paper right now is very focused on the convention debates themselves and what's happening in Philadelphia. And I would expand the lens and think more about and introduce more about the Confederation period and concerns that are emerging during that period among people like Hamilton and others who are very concerned that the Articles of Confederation just aren't working, that there are some fundamental flaws here about how it's designed, some of which are coming out of the revolutionary experience, but they're continuing in the Confederation experience. And so how's that conversation that's developing pre-Philadelphia then inform what the particular proposals that are being put on the table in Philadelphia itself? I think it would allow you to flesh out this vision of, one, it would flesh out more the concern that a set of actors have that we have a foreign policy nightmare about how we're doing things if we don't reorganize in some pretty fundamental way. And it would help you articulate more sort of what their potential solutions are that they're starting to imagine over the course of Confederation. It would, right now, there's sort of appearances about we don't, as you say, we don't want another edition of the Continental Congress. I think that's a failure. We need to do something else. But I think then revealing more about their concerns about the Continental Congress and why exactly they thought it was a failure and showing that as it was being exposed during the Revolution and Confederation would be useful then to getting you to Philadelphia and saying, okay, given this experience they learned, here's how they enter into Philadelphia, here are the particular proposals they put on the table, here's what they're fighting for and why they're fighting for it, and where does that wind up going, which turns out nowhere. But nonetheless, I think it would be a stronger paper ultimately if it's not so Philadelphia focused, but if you expand the lens out and bring in some of that. And finally, I think it would be, I think the paper needs to say more about what's at stake here. What's the point of digging up this history and telling us about this would-be potential constitution that doesn't exist. So you hint at it a little more actually orally than even you do in the paper, although the paper sort of began hints at it. There's IR literature, the concern about why can't the United States do better in thinking about grand strategy, et cetera, and maybe there would have been alternative constitutional design that would have done it. So that leads you potentially in a couple of different directions. One is the claim of the paper then that if only Hamilton had gotten his way as to what the Senate would look like, we'd have a grand strategy? That seems implausible to me. That's a big claim to try to make, but maybe. But the paper really doesn't try to make it really in any kind of systematic way. And so it'd be useful to try to think through, okay, is the burden of the paper then to tell us that there was a set of constitutional decisions made that leads to the current IR complaint, that we don't have enough of a grand strategy, and it could have been different, that we could have had a grand strategy if only the Senate had been structured differently, et cetera. And two, sort of, is likewise from that perspective, are there alternative explanations as to why we don't have a good grand strategy? And this is a function of democracy per se, for example, as opposed to the failure of the Senate as a constitutional design feature or something else, and the like. And so how should we think about that kind of element? I think you'd probably be better off, rather than suggesting there was a path forward that could have allowed us to be a much better grand strategic kind of thinking country than we in fact are, if only we had designed the Senate differently. Instead, to try to think about we have scholars now and strategists now who sort of say this is a real challenge for a country like the United States as to how do you develop grand strategy in with this kind of political system. And that's a challenge that some of the founders themselves recognize as well, even though they're dealing with it at a much earlier stage of the game. And they too were trying to think creatively about how would you overcome this challenge. And their big idea, or some of their big ideas, was we're going to design a Senate with a particular kind of component to it that would potentially solve this problem. Then we can bracket entirely whether that would actually work or anything else, but just to highlight as a matter of intellectual history and political history, they too saw the problem. They too were grappling with how to try to deal with it. And this was their proposal as to how to deal with it. So path not taken, but we can see an early effort to grapple with some of the same things we're grappling with today, which I think would make it clearer than what's at stake in the paper and what the paper then gives us at the end of the day.
Thanks.
pray that we can steal like 3 minutes and end at maybe 4:50 so that these folks can have a share. I'm going to actually start with Lee's question, which is there anything you folks briefly want to say in reply? And while they're answering, if people who have questions want to come to the microphone, maybe you can pose your questions kind of all at once and we'll let everybody respond to get the maximum numbers in.
Sure. Thanks, Professor Whittington, for all your comments. I think they're really all spot on. And I actually presented this maybe a couple months ago to a Stanford legal history workshop and received pretty similar feedback from Professor Rakoff, kind of an expert on the American founding. So I know I'm doing something wrong when two really smart, informed people give me similar feedback. Maybe you can help me think this through. The original draft of this paper actually didn't refer to the Anti-Federalist as such, but instead called them the Federalist, under the assumption that, in fact, they were advocating a genuinely Federalist system, as opposed to those who called themselves Federalist, kind of hijacking a name. They used that moniker to present themselves in a Federalist light, when in fact their inclinations were all very nationalist. And then, of course, people looked at that and read it and said, how are you calling George Mason, Martin Luther, and Elbridge Gerry Federalists? That doesn't make any sense. So I'm just kind of at a loss for how I characterize in a succinct way this cohort of people that were not necessarily skeptical about the Constitution per se, but the more nationalist implications of the Constitution. And I think in terms of organization, you're also right. I've heard this before, that if my most aggressive claim, in fact, is that that the Senate, to the nationalist mind, would be the repository of major foreign policy powers. So for that claim to kind of come at the tail end when I explain how that plan fell apart is a bad organizing principle, but it just makes more sense chronologically. So I have to, you've given me some really great ideas on how I can present that theme up front, then tell the chronological story towards the back about how it all kind of fell apart. And so thanks very much for all of your comments.
So we're going to have Sadie. I'm going to cut the queue now. So we're going to let David and Mark ask their questions, and then it's going to be it. Go ahead, Sadie.
Okay. Yeah. Thank you so much, Robert. So I agree with some of your criticisms of the ESG, or corporate social responsibility movement, to the extent that they're trying to impose mandatory ESG rules. What's different about my proposal is it's a voluntary opt-in market-based mechanism. So there's not going to be any involuntary transfer of wealth from the rich to the poor. I don't know if you care about whether movements of the market with respect to preferences that are not about ESG result in distributional effects between the rich and the poor. We don't usually care. We don't usually talk about that as a, okay, but so that's just one point. I think a lot of the criticisms are criticisms of a different proposal than mine. With respect to BlackRock, so BlackRock did withdraw from the Net Zero Alliance, but BlackRock still manages, according to the Wall Street Journal, more than $1 trillion of sustainable and transition-related investments. And in 2024, they crossed the threshold of $1 trillion, increasing 850% over the last 5 years. So I think it's premature to say that it's over, and maybe the fact that it keeps coming back is not a sign that it's a fraudulent, but it's a sign that people actually do continue to care about these things. And to the extent that there is some withdrawal, it might be because of the very problem that I'm talking about, is that there's a lack of a credible commitment mechanism, and people are not willing to throw their money at something that is not actually going to get them what they're after. And I'll just stop there and let the questions.
Sadie, if they announce tomorrow we're going to do this and it reduces value, every current shareholder loses right then.
All right, I want to let David ask his question.
Thanks. Thank you very much. Luke, I wanted to ask you where the separate independent judiciary may fit into your story about the absence of centralization, because Federalist 78, Hamilton celebrates independent judiciary. In 81, he has this comment about, we need this judiciary to, I'm going to summarize, preserve a coherent foreign policy so we don't get into wars. That's why the federal courts ought to hear these sorts of cases.
Actually, Mark, why don't you ask your question, and then we'll have people answer. And then I'm not going to stop Anthony because he works here, but and then we'll wrap.
This is also a question for Luke. Notwithstanding your distinction between foreign policy and grand strategy, wouldn't there be an argument that the U.S. At times has had a coherent grand strategy lasting over a long period of time, say the whole George Kennan contained the Soviet Union thing for 45 years? That's all.
Sure, great, thanks. I'll take Mark's question first. Absolutely. This paper right here is something of an offshoot of what I hope will be my dissertation project that is sort of a comparative constitutional project that uses constitutions to predict whether a state will have a grand strategy or not. Of course, the hard case, if I want to in fact claim that the US is somehow institutionally incapable of making and executing grand strategy, is this Cold War period where we prescribe to some policy broadly called containment for like a 45-year period. I'm happy to talk to you about like why I think that's a hard case and how I can explain my way out of it, but suffice it to say that one of the best revisionist historical accounts of that period from John Lewis Gaddis is entitled Strategies of Containment, and by that I mean we had something called containment coming from George Kennan most prominently, then Barry Goldwater introduced something called rollback, and then Nixon said détente, and then we finally have Reagan and H.W. Bush back to something resembling the containment that we saw under the Truman Doctrine. So if that's one coherent grand strategy, then I cannot explain why, how our Constitution precludes grand strategy, but I'm not sure it is. To the first question from David, I really appreciate that. I have to admit, it's not something I've given a great deal of thought to. I read kind of those Federalist papers in particular quite skeptically, because I think John Jay was originally given the portfolio to write those, and he's suffering a major brain injury at the time, so it falls to Hamilton, who is saying a lot of things in the Federalist papers that don't quite track the positions that he staked out at the Constitutional Convention. So I read those. I should read those closely, but not literally, and I have to give a little more thought about how he envisioned the federal judiciary adjudicating separation of powers concerns over foreign affairs. Thanks.
All right, so the last word / question / answer goes to Anthony.
So this is a question for Sadie, which is how is one supposed to kind of parse out genuine social commitments from the kind of noise, right, the nice sounding things? Because for anyone who flew here, right, while you're standing to get on your plane, the planes love to tout with stickers about how they're #1 in X publication. And so like every airline has some publication in which they're #1, and they tout that. But it's really kind of empty, right? Because it never gives you a sense of how they stack up against their actual peers and competitors. It's just like good sounding noise. So I guess Robert's saying there's costs to this. How are we sure there's an actual gain in the trade?
So it's a good question, and the kinds of signals that you're talking about are signals to customers, right? And this is probably very often the kind of greenwashing that makes people who would actually be willing to maybe give up some investment return for the assurance that the airlines are taking precautions with respect to their environmental effects. I can't believe any of this, so it doesn't matter. I'm not going to believe it. So this is the potential benefit of an adjudication mechanism. There are a lot of variables that that go into how credible the commitment can be. So it's. I don't know how much time I have to go into.
We're just over time, so.
Okay.
Yeah.
So how do you make sure that it's so it has to do with choosing a credible adjudicator, setting the commitment with the right level of specificity. There also has to be an audience for the information that actually cares about it and has the power to respond in the direction that's desired. So because it's a voluntary opt-in mechanism, it can be customized by a firm that has chosen to try to take advantage of a set of or provide value to a set of investors that care about this, right? And the specifics of how you set it up depend on what set of investors you're trying to appeal to and what they care about. But I would love to have you read the paper and we talk about it more. Thanks, Anthony.
All right, let's thank all of our panelists.